successful in California, Washington State, and Michigan. And this year he tried to have this going in, I believe, 6 states. Unfortunately, from his point of view, he's not going to be on the ballot in some of the states that he was trying to get in. Arizona and I believe one other state have found that the signatures that he produced to get his initials on the ballot were invalid, and they're not going to be there. But they still remain in Colorado, for example. Now, why is this important? It's important because Colorado is also a swing state. It's a state where both Republicans and Democrats believe they have a chance to triumph this year. And it's not clear how having an initiative, a racially tinged initiative, like a proposal to outlaw affirmative action, how that will affect who comes out to vote and how it might affect their determination or their decisions on who they're going to support. Because you have an African American or a black candidate who supports the concept of affirmative action against a Republican who does not. John McCain, before the Arizona initiative was knocked out, had declared his support for that initiative. And again, the initiative is to outlaw affirmative action, even though it's called the Civil Rights Initiative or whatever. I mean, this is deceptive advertising that these people do. I'll stop there because we've got an awful lot to talk about, but this just does give you some sense that it really does matter who gets elected in these terms. When a Supreme Court justice is seated on the bench, presidents are now usually trying to elect to select someone who's relatively young and is going to be able to stay on the bench for a long period of time, because these are lifetime appointments. So your grandchildren may still have to be looking at Clarence Thomas's face because he's young, vigorous, he takes awfully good care of himself, and he may be around doing his mission for a long period of time. So it really does matter.
Well, good morning. Thanks for the invitation, the introduction, sharing the space. I don't get over here very often since we're way over on West Campus. I was struck by, in particular, the comments by Dr. Morris about we, as an institution, it is true that we are an institution that would embrace the idea of a living constitution rather than one interpreted by way of originalism, which is ultimately, the idea that either the Constitution changes to reflect the values of today, or you go back to the time when the provision of the Constitution that you're talking about was discussed and ratified, and seek to figure out what it is that the framers intended. Not knowing what to expect, I figured, okay, I'm guaranteed not to repeat something if I argue for something that's unlikely to have been floated, perhaps in this particular room, and that being the case for originalism. But it's a specific type of originalism. That is, if we go to the Reconstruction Amendments and we look at the purpose and objectives of the 13th, 14th, and 15th Amendments, that being to move a group of individuals who had been held as chattel through the process of being declared for the purposes of the law persons, and thereby, getting themselves ready for citizenship, then the 13th, 14th, and 15th Amendments, if they are to be interpreted according to this originalism, should in fact be interpreted in a very racially specific, historically contingent way. Hence, things like reverse racism. You've all heard of reverse racism, true? Colorblindness, as a constitutional matter, would be completely irrelevant to the conversation because the amendments themselves are racially specific. So, what's the point here? The point is that in many respects, yes, I'm a law professor and I like discussing ideas. But the reality is, I would appreciate a judiciary much more if there was integrity and consistency rather than adopting one ideology or another, engaging in judicial interpretation for the matter of convenience in order to achieve a particular objective, which means that you're willing to say that the ends justify the means. If we were to, in fact, have a Supreme Court that consistently embraced originalism, much of the conversation about race and the Constitution in the United States wouldn't actually occur the way that it does. Conversations about affirmative action wouldn't be on the table. Congress has remedial authority to deal with the effects of, if you look at what's laid out there, both the purpose and the effects of racial discrimination. If racial discrimination is a reality today, then it remains on the table to be remedied. But what's happened is that we've had a court so caught up in, I'm trying to do it in a diplomatic way, achieving a particular result, being result-driven. And I hear Dean Date saying, political. Well, okay, yes, because the court's not supposed to be political. That's the other thing. I have to remember that, you know, some of you are coming to the table with a whole lot of information about this, and some of you are coming to the table new. If you're a judge, you're supposed to be sort of removed from the political machinations of what are called the political branches, the things that you run for, right? The executive branch, the legislative branch, those are supposed to be political. But the judiciary is supposed to be insulated from that. You know, way back in, 1803, Chief Justice Marshall, at that point, decided Marbury versus Madison established the principle of judicial review, which says that the Supreme Court says what the law is, but the people who actually make and enforce the laws are the other branches of government. So, if the Supreme Court was really about originalism, it would be about originalism regardless of which provisions of the Constitution it was interpreting. It wouldn't say that originalism applies, let's say, with respect to the First Amendment, but doesn't apply with respect to the Reconstruction Amendments merely because you disagree with, perhaps, the ultimate objective of those amendments, or don't have the will, as it were, to put in the work necessary to completely move a group of people who I will contend still do not enjoy full citizenship. If you have questions about whether that's the case, consider the current dispute regarding the legitimacy and the continuing validity of the Voting Rights Act. There's a case that the Supreme Court decided within the past week it's going to hear. Coming out of, it's the District Court for the District of Columbia, but you have a municipal water district, I think it is, in Austin, Texas, that claims that the Voting Rights Act should not, in fact, apply to them. Now, a brief overview of the Voting Rights Act, because it's very complicated. But basically, it's passed in 1965, and in the Voting Rights Act, there is a list of states that have to get any changes to their the boundaries of their voting districts, their electoral districts, approved by the Justice Department before they can put those changes in place. They're named in the act because of well-documented histories of disfranchisement of people of African descent. Texas, surprise, surprise, would be one of those jurisdictions. And the documentation isn't hard to find. There are a series of cases that were litigated in Texas involving the Democratic Party where they had whites-only primaries. It's in the law books. We're not making this up. So Texas comes to the table with this history and now is saying, well, based on evidence from, let's say, 40 years ago, we shouldn't, in fact, be held to this same standard. We should be entitled to an exemption from the rule. Because we didn't exist at the time, it's unfair, Congress is imposing this great penalty on us. But if the separation of powers works the way that it's supposed to, then the court would admit that Congress and other legislative entities have superior expertise to determine where remedies continue to be needed and where a particular jurisdiction should be relieved of its need to remediate past and continuing discrimination. Here we've got an indication that Congress said, with its recent reauthorization of the Voting Rights Act, these still remain problem areas. Despite that legislative determination, the folks in Texas want to say, we're going to the court to have you tell us not necessarily that our exemption isn't legitimate, but to challenge the ability of Congress to use its power under Sections 5 of the 14th Amendment and Section 2 of the 15th Amendment to continue to do the things that those amendments were supposed to do. In this case, ensure that people are treated equally and to ensure that people are not deprived of their right to vote on the basis of their race. Plain and simple. But the problem with the world as I'd like it to be in the world that we have is that we don't have a judiciary that's necessarily committed to integrity. I don't ever want to be a judge, so I really don't have to worry about the implications of that particular statement. And consistency. They're result-driven, which means that the folks who tend to get the short end of the stick are the people whose interests don't often coincide with the interest of the people who are driving the boat. So if you're unclear about the need to get registered by October, what's the date? Come on. Somebody in here needs to know. What's the date that you have to register by in order to vote? All right, so if you have made sure that all of your buddies, whether you're going to the club or wherever you're going, are registered, and then you ensure that you show up, and if you've got some extra time, you go to places where they might need people to watch the polls. They might need people to ride folks to the polls. They might need people to stand there and tell someone just because the person has been convicted of a felony, they served their time, so you at the very least have to allow them to vote, and if you're going to challenge it after the fact rather than tell them that they can't vote from the beginning. It means that you've got to be engaged, and I realize I've hit a generation gap, because I remember sitting out there, and it wasn't that long ago. But obviously, now that I'm over here, it's been a while. So I will take the opportunity to tell you what I was told when I sat in those very seats. You know, it's your responsibility. And if you don't think that it matters, no matter where you're from, understand, not just you, not just your children, as Mr. White has said, your children's children will have to live with the fallout from having chosen not to exercise a right that if the court was so inclined, it'd be more likely to decide cases that compromise and make it more difficult for you to, in fact, exercise your right to vote, rather than clear the way and allow you to exercise your right to vote as if you are a full and competent citizen.
All right. I guess you heard that, and I guess you understand what Professor Crooms is saying. I'm going to open it up for you to ask questions. If you don't, then I have a few, but I think about it, because there should be some questions coming from you.
I understood there were a bunch of journalism students in this audience, and I would expect journalism students to speak right up.
And while you're thinking, I will ask this question of our panelists. Who would you suspect, or what type of persons would you suspect that the presidential candidates would put in the Supreme Court should they succeed in becoming the President of the United States? What are the types, and then how might that influence the direction of the court?
I'll go back to what I said earlier. I mean, McCain has given us an indication of the kind of people that he would put in. He said that his two favorite justices were Scalia and Clarence Thomas. Mm-hmm. So my guess is that he would be trying to heaven help us find individuals who were similar in their approach to those two men.
And can we think about some of the things that Clarence Thomas has been an advocate of, or who some of the things that he has done that I think have caused people in the black community to really be upset about the direction?
The history of Clarence Thomas sitting on the court, to me, is fascinating. And again, I won't try to go over all of it, but when the first President George Bush selected Clarence Thomas after the retirement of Thurgood Marshall, who, as all of you know, was the architect of the Brown versus Board decision and first black on the Supreme Court, black member of the Supreme Court, there was a lot of clamor to have Thurgood Marshall's place filled by another black person. And I guess the first George Bush said, well, you want a black, I got a black for you. And the black that he got is Clarence Thomas. Clarence Thomas is